The Federal Appeals Court has thrown out a case against former Representative Jeff Fortenberry. His conviction was for lying to the FBI, and they've ordered a new trial. Why do we care about that? Why am I here reporting on that? And the reason is because this case should have never been tried in the venue where it was tried. And that is why Jack Smith chose to indict the Mar-a-Lago case in Florida rather than in Washington, D.C. And so we just want to go over a little tutorial on venue and what it means and why it's so important, because we don't want to end up like Representative Fortenberry's conviction that has now been reversed and overturned. So if you recall, Jack Smith, there was wide reporting at the time because don't forget, grand juries are secret by their very nature. And so we will never know if a prosecutor is presenting evidence to a grand jury unless, of course, the witnesses or their lawyers choose to tell us about it, because the prosecutor won't tell us about it. So we were getting lots of information. And of course, reporters were staked outside and could see various witnesses going into the grand jury. So that's another way that we found out. But there was, at the time when Jack Smith was presenting evidence to the grand jury in the Mar-a-Lago case, it was widely reported that that was happening in Washington, D.C. And so a lot of people were surprised when, myself included, when all of a sudden it went quiet. There were no more information about it or anything happening in Washington, D.C. And suddenly there was reporting of Jack Smith going into the grand jury in Florida. And people were criticizing Jack Smith for that and saying, why would he bring this case in Florida? And in Florida, you risk getting a judge like Judge Eileen Cannon, which is frankly the worst possible judge you can get for a case like that. She's not pushing the case to trial. She is making all sorts of rulings that are clear. She doesn't know the law. She doesn't have experience, or either that is the innocent explanation. The other explanation is because she was appointed by Donald Trump, she's doing his bidding. And once again, death by a thousand cuts, tiny little adjournments, because it's, as someone else, I can't remember who said, this is a game of inches. You know, he's trying to delay, because the long game for him is to not go to trial on the merits, because he will be convicted. There's absolutely no defense to the charges against him in the Mar-a-Lago documents case. So he doesn't want to go to trial on the merits. He wants to delay this so that it gets too close to the election to try him. Hopefully, in his mind, hopefully he wins the election. And unfortunately, the polls show him as winning right now, which frankly, I don't understand, but that's what the polling is. And if he were to go up against Joe Biden, and then he can just dismiss the case when he puts in his own attorney general who's in charge of the Department of Justice. He can order him to dismiss the cases and pardon the Jan 6 people and all the other people that he said, and pardon himself. So, that's what I think Waltine Nauda and Carlos de Oliveira are also banking on, and that's why they're sticking by his side, hoping that he'll pardon them if he becomes president again. So people were very frustrated because they're not going to trial probably before the election. Although Judge Cannon has kept the date, there's no way it's starting May, where it's scheduled to go at this point. There's just no way. The way she is ruling and not ruling, and the deadlines that she keeps extending and allowing people to miss, it appears that when May rolls around, or we get closer to May, that she will do everything she can to not allow that case to go at that time. But people said, why? Why would he do that? You have a much favorable audience in Washington, D.C. Why would he do that in Florida? But it shows that Smith knows what he's doing, because he's a law and order guy and didn't want his conviction overturned, because what good is a conviction if it doesn't stick, right? As a prosecutor, it's not enough to get a conviction if you have reversible error. That's a disaster. And so you absolutely want a conviction that is upheld on appeal and that will stick, because it's truly worthless. So the Fortenberry case was an appeal from the United States District Court for the Central District of California. It was a former congressman who was convicted of making false statements. So we call that a 1001 case, one charge. That's also a charge against Waltine Nauta and Carlos de Oliveira for lying. And in this case, it's reversed without prejudice, the Fortenberry case, meaning they can retry it if they go to the proper venue. And essentially, it was a campaign contributions case where illegal campaign contributions were alleged to have been made by a foreign national to him through straw donors. At the time, he was a member of Congress located in Los Angeles, right? The federal agents were located in Los Angeles, and the illegal contribution activity happened in Los Angeles. However, he wasn't charged, the congressman, with campaign contribution violations. He was charged only with lying to a federal agent, the 1001 violation. And so the lying occurred either in Nebraska, where he's a congressman, or in Washington, D.C. It didn't end in a lawyer's office. Nothing he did, the lying happened in Los Angeles. And so what they said was the government tried to argue that the lies had an effect on another investigation, which happened in Los Angeles. But the appellate courts rejected that and said the Constitution plainly requires that a criminal defendant be tried in the place where the criminal conduct occurs. And this having an effect on another case-based venue is not supported by the Constitution or in the text of the statute or in historical practice, and they reversed it. And that's exactly what would have happened in the Mar-a-Lago documents case with Trump, because it could be argued that he took the documents from Washington, and I'm sure that's why they were in the Washington grand jury. But the argument that he is charged with and the illegal possession of the national defense information and this documents, he might have, at the time that he took this, you can't prove that it wasn't an accidental taking, and you can't prove that he wasn't allowed to. In other words, he wasn't president at the time that it was removed from Washington. The one thing Jack Smith can prove is that at the time that he possessed it when he was no longer president, and when he refused to give it up, and when he was, waving around classified and top secret information to God knows who. There's that that audio recording of him talking about these Iran documents with the Mark Meadows biographer, and giggling in the background because, they're really important documents. I can't imagine that someone would giggle over that, but all of that you can prove was after the fact. Although that happened in New Jersey, actually, that part of it. But so much, the rest of it happened in Florida. And so it makes sense that Jack Smith didn't want to risk charging this in Washington, only to have it be reversed, because the actual crime, the gravamen of the crime, occurred in Florida. So that's the reason he went to Florida. He didn't want to risk that the case get overturned on appeal. As I said, that's a nightmare for a prosecutor, because you want your convictions to stick. You don't want to commit reversible error. So that's why, despite getting flack for doing that at the time, this is a perfect example. It just came down this week as to why Jack Smith was made sure that he had the correct venue so his case wouldn't get reversed again if it ever goes to trial. And so hopefully it does. But I'm Karen Friedman Agnifilo with Legal AF. Join me and my co-hosts every Wednesday and Saturday. Thanks so much for listening.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.